It began like any other hearing, orderly, procedural, almost mundane. A polished young attorney stood at the center of a federal courtroom, surrounded by government lawyers, court staff, and the steady gaze of a man known to strike fear into unprepared litigators. Judge Anthony Terenga was no ordinary federal judge. With 3 decades on the bench, he was revered for his intellect and feared for his intolerance of anything resembling disrespect. His rulings were crisp, his demeanor unsparing, and his courtroom the tightest ship in the Eastern District. Before him stood Karoline Leavitt, a rising legal star in conservative circles. Young, confident, and fiercely articulate, she had made headlines for defending First and Fourth Amendment cases, and this time she came representing the Liberty Foundation, a policy think tank facing an aggressive subpoena. At stake was more than just documents. The government wanted internal communications, emails, drafts, memos, between former executive officials and the foundation. Material Leavitt claimed was protected by executive privilege, even though her clients no longer served in office. But Judge Terenga wasn't interested in theoretical privilege. He wanted compliance. And within minutes, what began as a procedural skirmish would escalate into a courtroom standoff so intense, Leavitt found herself staring down the threat of jail time. Until she made one move that flipped everything. The courtroom was still. A marble clock ticked overhead. Judge Terenga leaned forward from the bench, adjusting his glasses with the precision of a surgeon about to make an incision. Judge Terenga: "Miss Leavitt, this court issued a clear directive. Where are the documents?" Karoline stood motionless at the podium, her hands steady on the edge. Her tailored navy blazer couldn't hide the weight she carried, not just as counsel, but as the last firewall between her clients and a government determined to breach their files. From the other side, Assistant U.S. Attorney Adam Keller pounced. Keller: "Your Honor, opposing counsel has failed to comply with lawful discovery. This isn't a debate. It's defiance." Gasps flickered in the gallery. Reporters began scribbling. Keller was pushing for blood. Judge Terenga, stern: "Ms. Leavitt, I'm growing impatient. Is it your position that you can unilaterally ignore a federal subpoena?" Leavitt, calm, measured: "No, Your Honor. My position is that a recent Supreme Court ruling, handed down just 4 days ago, alters the constitutional framework we're operating under. My client's communications may fall under continued executive privilege, even in a post-administration capacity." She slid a single binder across the table. Inside, a revised privilege log, annotated and flagged with excerpts from the Supreme Court's decision in Department of Commerce versus New York State Archives. Judge Terenga, cold: "Spare me the pretext. If you think you're going to stall this court with procedural gymnastics, you're sorely mistaken." Keller, pressing: "We asked the court to issue a contempt warning. We've been more than patient." The judge's gavel tapped once, lightly but ominously. Judge Terenga: 5-minute recess. When we return, Ms. Leavitt, you'd better be prepared to defend your position, because if I find you've acted in bad faith, you won't be walking out of this courtroom today. The threat wasn't metaphorical. The judge was invoking Rule 42B of the Federal Rules of Criminal Procedure, the authority to hold counsel in summary contempt. Leavitt exhaled. She knew the line she was walking, but she also knew the law. As the court recessed, she gathered her notes with quiet determination. This wasn't a game. This was precedent in motion, and in just 5 minutes, she would return. Not to back down, but to flip the courtroom on its head. 5 minutes. That's all she had. In the hallway outside courtroom 17B, Karoline Leavitt stood motionless. She didn't speak to her co-counsel. She didn't check her phone. She simply flipped open her binder to page 143, then to the handwritten notes she'd scribbled in the margins just hours before. She wasn't preparing for a routine argument. She was preparing for a counterstrike. Back inside, the courtroom reassembled like a coiled spring. Reporters whispered. The U.S. Attorney's team looked confident. And Judge Terenga returned with the same hard stare, unchanged, unreadable. He sat. He nodded. Judge Terenga. Proceed, Ms. Leavitt. Karoline took one breath. Then she launched. Leavitt, calm, clear. Your Honor, I'd like to direct the court's attention to footnote 7 of the Supreme Court's majority opinion in Department of Commerce versus New York State Archives. The court explicitly acknowledged the enduring nature of executive privilege for former senior officials when advising on matters of ongoing national policy. My clients are not withholding documents. They are protecting constitutional boundaries the Supreme Court has reaffirmed. She stepped forward, holding up a certified copy of the ruling. Leavitt, firm. This is not obstruction. This is constitutional. Adherence. And any attempt to compel disclosure before this privilege is adjudicated on the merits would violate established precedent. Judge Terenga leaned back in his chair. His expression didn't change, but something in the room did. Keller, snapping back. Your Honor, this is a distortion. That footnote is not controlling law. It's dicta, and counsel knows that. Leave it, without blinking. Dicta or not, federal courts have cited it in 3 recent privilege rulings. And in Patel v. Department of Energy, the D.C. Circuit treated similar language as persuasive in a near-identical dispute. She was drawing lines, citing cases, laying down markers. And more importantly, she wasn't rattled. She was in command. The judge looked down. He flipped through her binder, scanning the references she'd annotated in advance. There it was, page after page of precedent, tailored precisely to the case at hand. A calculated legal ambush, and suddenly, the silence in the courtroom wasn't suspense. It was respect. Judge Terenga measured. Counsel, you're asserting that compelling production now could violate your client's Fifth Amendment and separation of powers protections? Leave it. Yes, Your Honor, and I'm prepared to file an emergency motion for interlocutory appeal under the collateral order doctrine. That would stay discovery until this privilege claim is reviewed. That was the move. A strategic bombshell, an emergency motion for an interlocutory appeal, rare, powerful, and legally justified. If accepted, it would freeze the government's demands and send the matter to a higher court before any further compliance could be forced. The courtroom shifted. The tension didn't vanish, but it was no longer aimed at her. Judge Terenga closed the binder. He stared at her for a long moment, as if reassessing everything he'd assumed about this young attorney just 10 minutes ago. Judge Terenga, quietly. You came prepared. A pause. Then, Judge Terenga. Very well. File your motion. This court will withhold any contempt ruling pending appellate review. Just like that, the storm broke. The jail threat dissolved into thin air, and Karoline Leavitt had not only protected her clients, she'd earned the court's respect by wielding the law with precision, not defiance. She didn't smirk. She didn't gloat. She simply gathered her notes and walked out of the courtroom, the same way she walked in, steady, focused, and unafraid. But this time the headlines wouldn't call her a firebrand. They'd call her something else, a legal force. By the end of the day, the federal courthouse in D.C. was buzzing, not with verdicts, not with breaking news from the Department of Justice, but with one name, Karoline Leavitt. A young legal voice had gone head-to-head with a veteran federal judge, and not only held her ground, she reshaped the courtroom conversation. Outside the courtroom, the press had been waiting. At first, they expected a contempt ruling, a scolding, maybe even a dramatic escort out in cuffs, but instead, they saw her walk out calm, collected, and silent, with Judge Terenga's words still echoing in every reporter's notebook. File your motion. Contempt is withheld. That single sentence sent waves through legal Twitter, cable panels, and every inbox from Capitol Hill to K Street. Some saw her as reckless. Others, as brilliant cut-to-reaction quotes, paraphrased. Karoline Leavitt stood on the edge and never blinked. She didn't defy the court. She defined the debate. That was a constitutional clinic. Within hours, the Liberty Foundation released a statement praising her unflinching commitment to constitutional principles. Conservative commentators hailed her as a rising star in the legal arena, a constitutional warrior in heels, as one blog put it. But not everyone was celebrating. From the DOJ's side, senior officials expressed frustration. Behind closed doors, some saw her move as an unnecessary escalation, one that might delay proceedings and invite political posturing. And inside the judge's chambers, only silence. Judge Terenga made no further statements, no rebukes, no elaborations, just an official docket entry noting the court's decision to pause contempt and allow for appellate motion practice. But the message was unmistakable. In a courtroom where authority rules and deference is expected, Karoline Leavitt had challenged the process not with drama, but with doctrine, not with protest, but with procedure. And it worked. For those who watched closely, it wasn't just about documents or executive privilege. It was about something deeper. What it means to stand firm in the eye of judicial power, to speak law to power without flinching, and to remind the system that even in its most rigid chambers, the Constitution still has its say. Behind the public buzz and legal headlines, another story was unfolding, quieter, tenser, and far more personal. Because while Karoline Leavitt had walked out of that courtroom with the press at her heels and praise in conservative circles, she also walked into a different kind of fire. Back at the Liberty Foundation's D.C. office, the mood was split. Senior partners admired her composure. Some even toasted her boldness in private. But others, seasoned attorneys, policy strategists, institutional minds, worried. Whispers in the hallways. She's brilliant, but this could have backfired terribly. Judges have long memories. If Terenga turns, she's finished. Karoline, for her part, remained composed, but not untouched. That night, she stayed late in her office, poring over appellate strategy. The brief had to be perfect. No grandstanding, no rhetoric, just precision, because now everything she'd done in that courtroom would face scrutiny from a higher bench. Even her allies urged caution. One mentor, a former federal clerk, called her privately. His voice was steady but urgent. "You played it well, Karoline. But don't mistake survival for success. You've opened a door few walk through unscathed. Be ready. They'll test your every motion now." And then there was Judge Terenga. No contempt ruling, no public rebuke, but insiders said his chambers had gone cold. No scheduled hearings, no new orders on the docket, just silence. Silence in federal courtrooms doesn't always mean peace. Sometimes it means the storm is still gathering. Karoline knew the rules had changed. This wasn't just about emotion anymore. It was about credibility, legitimacy, future access to that courtroom and others like it. She'd made her mark. But would she now be marked? Because in Washington, victories often come with a cost. A rising star can draw attention. But stars that rise too fast, they also draw fire. Days turned into weeks, and the headlines slowly faded. But what happened in Judge Terenga's courtroom that day left a deeper imprint on legal strategy, political calculation, and Karoline Leavitt's career. Because in a town where perception often outpaces truth, the story wasn't just that. She avoided contempt. It was how she did it and what it revealed. Conservative media hailed her as a warrior for constitutional rights. Clips of her poised rebuttal and precise legal citations went viral on policy podcasts, fueling debate on the limits of executive privilege. This is the kind of clarity the courts need right now, one constitutional scholar declared. She didn't defy the law, she clarified it. But not everyone applauded. Progressive legal circles accused her of grandstanding, of weaponizing ambiguity in the law. Some claimed her maneuver threatened to erode judicial authority. And Judge Anthony Terenga? He never issued a follow-up order. But insiders noted that his future rulings grew more precise, perhaps even more cautious, when it came to privilege disputes. Karoline's legal move hadn't just spared her a contempt charge. It had shifted the temperature of the debate. In quiet corners of legal forums and strategy rooms, her argument was dissected and duplicated. Her name was added, sometimes with respect, sometimes with resentment, to the short list of attorneys willing to challenge federal norms in open court. And Karoline? She didn't rush to TV interviews. She didn't declare victory. Instead, she took on a new case, quieter, more technical, a move many saw as deliberate, controlled, strategic, because she understood now what few young attorneys ever grasp so early. The courtroom isn't just a place for arguments. It's a proving ground for character, and sometimes the sharpest victories are the ones that don't look like wins at first glance. Karoline Leavitt walked into that courtroom with a brief and a principle. She walked out with a warning, a precedent and a reputation that Washington would not forget, not anytime soon.